Thank you. Good morning, all. My name is Daniel Sorensen. I have beside me here Jesse Langelet. We're both lawyers at a law firm called Sorensen Smith. We have offices in Chilliwack and Langley. We advise small businesses and individuals on a large range of issues. I guess I'd say we pretty much do everything except for criminal defense. I'll just go through our slides here, and we're going to cover a pretty wide number of subjects today, and a lot of these subjects could be full presentations in and on their own. We're going to go through what changes are going to be to the precedent package that we have provided previously. We're going to talk about informed consent, professional liability, complaints, a bit about cultural competency, data protection and virtual practice, referrals and collaborations, technology and ethical marketing, subject to very limited exceptions for things such as a medical emergency. Generally, any sort of treatment requires informed consent. And that means that as dietitians, you'll want to provide clear, comprehensive, and understandable information about the proposed treatment or services. And that includes explaining foreseeable consequences, risks, benefits, and speaking about alternatives. And as a part of this, you'll want to practice what is called a sensitive practice. So that means that you'll want to provide clear language. You'll generally want to allow clients to have a support person or bring a support person with them. If for some reason touch is required, you'll want to inform the patient or client before that occurs, and certainly avoid any unnecessary physical contact. And you want to give opportunity for the client to ask questions and have opportunity for the client to have opportunity to answer those questions. And consent also needs to be revisited regularly. There are, I suppose, professional liability is essentially, I suppose, what we as lawyers spend much of our time either avoiding or solving. And there's quite a few different sources where professional liability can arise. First of all, as dietitians, you have something called a duty of care to your patients or clients. And what that generally means is that you have to conduct yourselves in a manner equivalent to essentially how a reasonable dietitian in those circumstances would conduct themselves. And what a reasonable dietitian would do, that's often determined by reference to laws, regulation, any sort of guidelines or policies published by the college. If it's a circumstance where perhaps there isn't a guideline or regulation or rule, then in those circumstances, it would often be determined by reference to industry standard.